Just, Simiron, if we can just have a mic check.
Good morning, everyone.
Okay, very good. Loud and clear. Good morning, councils. And just as Torres, we can go ahead and start. Yes, okay, thank you. The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case.
You are muted, Trina.
I apologize, Your Honor. This is Supreme Court case number CRA20-001, People of Guam Plaintiff Appellee versus Alas Damanto Simiron, Defendant Appellant. Appearing for the Plaintiff Appellee is Attorney Marianne Wallachuk. Appearing for the Defendant Appellant is Attorney James M. Maher. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Maher reserves 10 minutes.
Thank you. Attorney Maher, you may proceed.
Thank you, Chief Justice Carbolito, Justice Torres, Justice Merriman. I have two principal challenges to this judgment based on jury instruction errors, as I allege. The first is the defense of another instruction was incomplete. The government concedes that point. However, there is a disagreement as to the legal consequences of that. My second challenge, of course, is to the instruction regarding intoxication. It was limited to only specific intent crimes and was not given over objection by defense counsel to murder and manslaughter that were pled as reckless crimes. So as to my first argument, as I said, the government concedes there was error. Their disagreement with Mr. Simiron is that the error was not substantial and did not affect Mr. Simiron's rights, and therefore, in effect, was harmless. Our disagreement is simply this. The government alleges that the evidence was overwhelming, pointing to guilt. We dispute that. There is only one witness, which was a government witness. And that witness, Detective Chavez, made it very clear that Mr. Simiron heard the co-actor and the victim fighting. He heard fists. As the vehicle stops, he walks around from the passenger side front where he was, and he sees, according to Detective Chavez, the victim with a metal bar poised to strike the co-actor, Mr. Malo. And at that point disarms him. Mr. Malo picks up the bar and strikes and kills the victim. Now, the court did give an instruction on defense of others, but forgot, inadvertently I assume, to remind the jury that the government had the burden of proving the justification defense of another, disproving it, beyond a reasonable doubt. That instruction was not given, and the trial court judge also forgot to instruct the jury that in the event the government did not disprove this justification defense of another beyond a reasonable doubt, it had the duty to acquit Mr. Simiron. And
so, Mr. Maher, if I just, if I can ask you to pause, because you argue that the government did not present overwhelming evidence and that there was only a single witness. But I thought that we also had the defendant's written statements, his video enactment of the crime, and forensic evidence. And when you couple that with the description of the testimony in reference to how the events unfolded, I'm not understanding that you just discount this other evidence.
Well, The government cited to, well, it was a little bit unusual what the government did. It just cited the transcripts, and primarily the October 23rd, 2018 transcript. And in citing to that, took various statements that were either ambiguous or contradictory to form an argument that the evidence was overwhelming. Now, it's true that the video reenactment was played to the jury and there was a written statement, etc. If the court were to review the 10/23/18 transcript, the court would see that the direct examination of this detective was weak, I guess. A very imperfect picture of what happened, the chronology, and who did what emerged from that direct examination. It was on cross-examination by defense counsel in obviously the same witness, same day, that Mr. Spivey clarified exactly what the written statement said and what Mr. Simiron said. And that statement made it very clear that, and I'm actually looking at the transcript, that the version of events, and Mr. Detective Chavez affirmed this as the correct version, that Mr. Simiron, as I said, heard these people fighting, got out of the car, saw the victim with a bar, disarmed the victim, and co-actor took bar, struck and killed victim. That is exactly what Detective Chavez affirmed on cross-examination as to the written statement of Mr. Simiron and as to the reenactment. And that begins on page 63 of that transcript and begins on 62 and ends on page 63. Now, that essentially was the government's case. It was Mr. Simiron testifying through Detective Chavez. And
let me ask you, in this case, there were instructions, or the court provided instructions on the definition and the general requirements of self-defense and the use of deadly force, right?
That's correct.
So the jury had those instructions, including the limitations on the use of deadly force that
Yes.
are provided for in the statute. So while the focus, here is your argument that the defense of another instruction did not include the burden of the government and the fact that they should acquit him. And I think the government, acknowledges obviously that was error, and it probably was plain error. But when you look at affecting Mr. Simiron's substantial rights, and I know you have an argument, and I intend to ask the government that question about how you believe it did, but doesn't the evidence demonstrate that he didn't justifiably use force when it was no longer necessary to protect himself? I mean, when he punched Alvarez in the face, and that was the testimony, and Alvarez dropped the pipe, and then he was telling his co-defendant, well, no, it wasn't co-defendant, they were telling Sally to hit him over and over again. Why was he exerting, in accordance with 7.88b, he made no attempt whatsoever to avoid the necessity of using deadly force? It doesn't seem to be justifiable what occurred after he had already disarmed him.
Let me just clarify before you answer that. Just stories, man, there was error and clear error, not that there was plain error.
Yes.
But
I'm sorry, yes.
I just want to clarify.
Yeah, that's what I meant. Thank you, Chief Justice.
Well, as to the scope or the excessive use of force, I don't believe it's disputed by the government that it was the co-actor that struck the victim and killed the victim. And once again, the transcript, the testimony on who said what is very, very ambiguous. Detective Chavez went back and forth under direct examination, and it's not clear that Mr. Simiron directed Mr. Malo, after disarming Mr. Alvarez, to strike Mr. Alvarez with the pipe. I mean, that's the government's contention, but that's not exactly what the testimony shows. That's just not what Detective Chavez stated unequivocally. He said he couldn't remember quite often if you read the transcript. So it's it's indeed murky.
Was there any evidence that Alvarez was the aggressor in this at trial?
No, not from the perspective of Mr. Simiron. No, all Simiron testified to through Chavez was that he heard these people fighting, punches. But he didn't testify or tell Detective Chavez that he saw Mr. Alvarez strike Malo first or initiate any sort of confrontation with him.
Is there a duty to retreat imposed on Mr. Simiron before he can use deadly force?
Well, okay, Justice Torres, that's assuming he used deadly force. His testimony through Detective Chavez was he did not use deadly force. It was his co-actor that used deadly force. He simply disarmed Mr. Alvarez using a chokehold, much like in the Gagarita case, where he gets behind him and chokes him, and the man releases the weapon. And at that point, the co-actor, Mr. Malo, grabs it and strikes Alvarez. So in effect, his participation ended after disarming him. And Mr. Alvarez was still alive. I guess that's the point. He didn't kill him.
So at that point, when the co-defendant had the pipe and there was no longer any threat that the victim here, Mr. Alvarez, was capable of exercising deadly force, then at that time, didn't the defendant here, Mr. Simiron, have a duty to retreat under the defense of other instructions instead of continuing the chokehold, and ended up it being a deadly result?
I think the testimony was he did. Once the weapon was out of Mr. Alvarez's hands, because he had been choked by Mr. Simiron, I don't believe there's any testimony, stayed on top of him and choked him and continued to hold him down as Mr. Malo beat him with the...
That's not my recollection of the testimony. I don't think that's the way from the result of the jury may have seen it, and that there was then Mr. Simiron's where the co-defendant continued to beat him over the head and even in fact hit Mr. Simiron accidentally with the pipe while he continued the chokehold. So I don't necessarily see the evidence that he released him once he no longer had the pipe.
And if you look at the testimony of the jury trial on October 23rd, and specifically, I think at pages 40 and maybe 49, that he says he kept Alvarez in the chokehold until he stopped breathing. And that was, after he was being hit, after Alvarez was being hit.
Well, I can see where Justice Torres, you're citing to that testimony. He said he He said he released the chokehold and the driver was gasping for air. And then it goes on to talk about if Simiron remembered Malo.
And well, it's look at on page 49, and he tells him to hit him, with the pipe, and he started to whack him over and over again. And then he says, while I was choking him, and the answer was, that is correct. I heard him stop breathing. I heard him stop breathing. I let him go.
That's page 49. I'm on 49.
Yeah, on lines 12, 11 through 13.
Okay. So the detective says, it sounds like, yes, that's what he wrote. So I'm trying to remember whether he told me that or not. Question. And this says, while I was choking him, that is correct. Question. I heard him stop breathing. I heard him stop breathing. I let him go. That is correct. Well, okay. Once again, it's I think Mr. Spivey clarified the rather conflated and ambiguous testimony. The detective was not sure quite often when asked questions. And those, even though they're leading questions, they're loaded with the response the government wanted, they still got rather weak responses. Anyway, that's my reading of the testimony.
Do you want to move to your second issue?
Yes. Mr. Spivey objected to this and requested a instruction that would potentially negate the reckless element of murder and manslaughter based on the intoxication defense. And he actually submitted or filed a written notice of that defense. And as the court is probably aware, they went back and forth on that, and the government's position was it only applied to intent crimes. And our position is that it applies to crimes that are reckless as well. And our primary reliance on that is an interpretation of 425, 9 GCA 425 and 430, specifically 4.30 subsection C, and the comments to that. And at the very end of the comments, there's a discussion about the difference between intent and recklessness. One is a desired result, one is a foreseeable result. But the comments to 4.30 subsection C is that the unjustifiability or the justifiability of reckless conduct is something for the jury to assess.
Yeah, but your argument seems to maybe not read out, but downplay the effect of section 7.5 AC, 9 GCA 7.5 AC, where there it specifically says that a person is reckless, acts recklessly if the reason why he doesn't appreciate the risk of the surrounding circumstances is as a result of his voluntary intoxication. In other words, if the argument is that the intoxication will negate the mens rea, and it's a reckless mens rea, and if due to the person's intoxication, he now cannot appreciate the risk of the circumstances that if he was to act in a certain way, that it would result in criminal behavior. And in that particular instance, 7.5 AC says you can't use voluntary intoxication to negate the mens rea when it's a reckless conduct, because he doesn't appreciate the risk as a result of his involuntary intoxication.
Well, that was the government's argument as well, and
That's what the statute says.
that's what the statute says, and that's correct. And I submit that these statutes have to be read together as a whole. That was my argument, that yes, it does say that, but does it supersede or supplant 4.25 and 4.30? I think, and that has to be the approach to this, how to harmonize these. And I think that is not what the government did. The government.
And how do you harmonize the effect of 7.58C specifically to reckless mens rea, where voluntary intoxication affects the defendant's appreciation of the intended risk, or doesn't appreciate the risk involved in him acting in a certain way because of his intoxication?
Well, it's difficult because we have statutes that would directly conflict with that. I mean, the 4.25 legislature has said we cannot find a person guilty unless that person acts intentionally, knowingly, or recklessly, or with criminal negligence, as the law may require. So they then go on to explain in 4.30 culpability. And clearly the culpability encompasses reckless conduct. So,
I mean, but it doesn't there. I don't think the government anyone disputes what you're saying. It's just that the analysis just doesn't end there.
well, I think this, as the comment makes clear, the jury is to assess this, and the jury cannot assess this unless they're instructed. And that was the problem. They never got the instruction. That was Mr. Spivey's action.
But I don't understand why the element of reckless, I mean, because your argument is that because of the self-induced intoxication, he was not conscious enough to make the reckless or to make the decision, the culpability argument with the awareness of the substantial risk, essentially, for acting recklessly. I mean, that's essentially the argument. But 7.58C says, even though your disregard is not conscious, you will still be deemed reckless if your not being conscious is due to self-induced intoxication. So the element of reckless is supplied by virtue of, even though he's not conscious, even though you argue he's not conscious, to understand the awareness of the risk involved, 7.58C supplies that.
So I guess you're arguing that the shortcoming is that a trial judge didn't instruct the jury on 7.58C. And if that's the case, how would your client prejudice? Because all the instruction would have said is your client acted recklessly if, as a result of him not being aware of his surroundings and the risk in reference to the circumstances, is because of self-induced voluntary intoxication. And if that's the case, then he has acted recklessly, and then the trial instruction would have defined that your client acted recklessly. I don't know necessarily if that was in the interest of your client to ask for such an instruction.
Well, yeah, the focus, or at least the slant of this argument, is not on the fact that this intoxication was self-induced. It is on the fact that the statute, you have to act with, as I said, the foreseeability of the result or the consequence. And if that is impaired, even though the person voluntarily impaired him or herself, the statute says that they have to be aware. It's I guess what I'm suggesting is the culpability, even though the person is culpable, there still has for getting drunk, for example, there still has to be awareness of the danger, the substantial danger they are creating by their conduct. It seems the government's position is based on the statute is, well, you get drunk, you're therefore reckless. Okay, maybe you're reckless because you got drunk, but that doesn't necessarily mean that you're aware of the danger because you are intoxicated.
That was not the argument, Mr. Maher. The argument is not that he acted recklessly to get drunk. The argument.
No, I know.
Okay.
But I'm just, there seems to be a difference in focus here. The statute simply says they don't qualify it in 4.30, it's not qualified. They're just saying if the person doesn't have the mental or cognitive ability because they're for whatever reason impaired, they don't qualify it that way. They just simply say that is something that the jury has to be instructed about. They have to know that.
But and the 7.58C, I don't know if you have the code in front of you, but if you look at it, it supplies that recklessness element even when the person is not conscious, if that his not being conscious is a result of self-induced intoxication. So the culpability, the requirement of reckless is still there. It's just that the recklessness is provided for by 7.58 that's saying you're reckless with respect to an element of offense, even though you're not conscious. If you're not being conscious is because you've self-induced intoxication. So it's the recklessness remains. It's just provided by a separate statute.
Supplanting 4.30 then.
Well, it specifically says a person is reckless with respect to an element of the offense, even though his disregard thereof is not conscious, if his not being conscious is due to self-induced intoxication. So it does provide that he is acting recklessly under 4.25 and under 4.30 by virtue of even though he's not conscious, even though he's not being conscious thereof because of self-induced intoxication. So the statute does provide that. And I mean, if the argument is that's not allowed, the legislature can't do that to provide that, then that's a different argument. But your argument was that the recklessness provision can't be obviated, and it isn't to the extent that the legislature supplies that. He's still reckless, but it's provided under a different. He's reckless, notwithstanding the fact that his disregard of the risk is not a conscious one.
I note, Mr. Maher, you have 3 minutes remaining, and I just want to know if you want to reserve your remaining time.
Yes.
And Justice Merriman, do you have any questions before we move to the government? All right. Attorney Wallace-Chuck. And if you want to then respond, Mr. Maher, in anything that Justice Torres has commented on, you have the remaining time.
No, Chief Justice. I'm fine.
Attorney Wallace-Chuck, you are recognized.
Chief Justice, may it please the court. The defendant here is arguing that there were errors in the jury instructions as to defense of another and intoxication. The people's position is that there was no jury instruction error here, and the court should affirm the judgment below. I will address the defense of another jury.
How can there not be error in the jury instruction on defense of others when they failed to specifically instruct the jury as we indicated they should?
Yes, I should have said there's no plain error, because plain error is a 4-part test, and all 4 parts of the test have to be met. And so, yes, this jury instruction did not meet the first and second parts of the test. We conceded that this instruction, and now that is the law of Guam, given the court's decision handed down in People v. White. So now it is the rule that if you're going to have a defense of another jury instruction, then you have to tell the jury that the burden of proof is on the people to disprove that defense. And if they don't, the jury will have to acquit the defendant. And so that was not done here. So elements 1 and 2 are met. There's an error. The error is clear. Where we get hung up is the next part of the third part of the 4-part plain error test, which is, whether there was an effect on the substantial rights of the defendant, which means
Mr. Maher argues there was prejudice suffered by his client, and that is the jury, evidenced by the fact that the jury acquitted him of aggravated murder with a special allegation. And so he says that it's reasonable to infer that the jury had some reservation about the strength of the government's case and whether or not he acted with some justification. What is your response to that argument?
So I don't think that's the reason why the jury acquitted him of the first charge. If you'll notice, he was not found guilty of any of the special allegations, and the first charge has to do with committing a murder during a robbery. So it's like a felony murder, and he also was not found guilty of the robberies. So that's why he wasn't guilty of that murder charge, not because the people's case was weak, and if they had been instructed properly, they would have found that the people did not carry their burden of proof. So I don't think that that's the reason why they found the way they did. I think it has more to do with the type of charge that was and the other charges that followed from it.
What about their other argument that the government agreed to the instruction below, and so should be prevented from on appeal arguing against the giving of the instruction or its effect on his client?
To that, I would say, Your Honor, that the people didn't agree to this instruction. What happened was that the defendant had, I think he had a disagreement with the alternate public defender. There was some violence threatened. He was shackled. It just became, the court was worried about another outburst. And I think everybody was a little bit nervous at that point by the time we got to the charging instruction. And so the court didn't make the necessary finding. The judge did not say that, this instruction is warranted based on these facts. All she did was say, I'm going to give this instruction. Does anybody object? And nobody objected. And, non-objection just means that you don't take a position. It doesn't mean that you agree with that position. So in this case, the people didn't agree with it. So that's another thing that distinguishes it from what the people did in the White case, where the people said, that they were okay with this jury instruction. There was enough evidence to warrant it. Nobody said there was enough evidence to warrant the defense of another jury instruction in this case.
So where in the record can we find that the people did not agree?
There's a part during the charging instruction where the court says, any objection? And they both said no. I don't remember exactly the page. I can try and find it. It's in the excerpts of record.
I agree with you saying, but how does no opposition transfer to not agree? It seems to me if you have a concern, you should raise it at that point.
Yes, but I think maybe the reason the people didn't is because it was so weak that I think they were just willing to let it go and get this defendant through this experience, because he was not reacting well to it.
We can't rely on your speculation. Where in the record does it say they didn't agree to the instruction?
They only didn't object. So I can't say that they didn't agree. I can only say that they didn't object, and that in general, when you don't object, that means that you don't take a position. It doesn't mean that you agree with that. And also, the defendant also argues that the fact that the court gave that jury instruction means that the court believed that it was warranted, but that's not necessarily true. The trial courts often give jury instructions that aren't warranted, and they don't make any findings that the instructions are warranted. So we would argue that that's what happened in this case as well. So also, even if you find that we're not allowed to argue this, as the court ruling on this issue, you have a duty to go through those 4 parts of the plain error test. And so you can independently look at the 3rd factor and decide whether or not the defendant's substantial rights were prejudiced in this case. And I would submit that you will find that they were not, because
But would we reach that question if we determined that the government waived their ability to make that argument on appeal?
yes, because the court can issue a decision on any legal basis. It doesn't have to follow what the parties are arguing. So it's up to the court's discretion to decide that. And we would argue that the court would find that the instruction was not warranted under the 3rd part of the plain error test. And so since all 4 parts of the test are not met, that means there was no plain error. And that means that the defendant's conviction should not be reversed. He should not get a new trial. He was not entitled to this defense of another jury instruction. And I will also point out that the defendant is only relying on one witness's testimony, but as the court pointed out, there was a whole lot of other evidence, and mostly the defendant's own words in the video, which the jury saw at the trial, and they also saw at a replay during deliberations. And that's the point where the defendant made the most headway into the story underlying what happened. If I have this right, I think he said that, he got out of the car, he heard people striking blows, he came around to the other side, he saw his friend Mallow Sally on top of the victim was pulling out a pipe, the defendant pulled the victim out of the car, and then he choked him and punched him until he dropped the pipe, and then I think he kicked the pipe far away, and he dragged the victim over to the tree line, and then, which is across the street from the truck that they were all in. And then the co-actor grabbed the pipe and came up and started hitting them. And the defendant said, yeah, hit him some more. So he was not defending anybody else at that point. There's no reason for this instruction to have been given. He should have retreated. They both should have retreated when it was safe to do so, and they didn't. And they ended up with, the victim ended up dead because of this. So we would argue that defense of another, the instruction was defective, but it did not affect the outcome. There was sufficient evidence here for the jury to find the defendant guilty, and the court should have affirmed the judgment below. It's like the People v. John case where there's overwhelming evidence of guilt. We believe the evidence here is overwhelming. I'm turning to the other instruction. As the court pointed out, there are 2 statutes here, and the defense has, stated that they cannot be harmonized, and they are, there are discrepancies, and the defense is arguing that you should apply only 4.30C, but 7.58C also applies, and it's more specific because it has to do with this type of situation, whereas 4.30 is general. And under the rules of statutory construction, normally, the specific trumps the general. And so we would argue
But
that
you didn't really raise the issue or the importance of 758C in your brief. Your focus was more on the statutory differences, the extreme indifference to human life. You didn't really focus on this in your brief.
Yes, Your Honor, that's right. But I think that's because the defendant didn't make a big deal of this argument in his opening brief. If there had been more on that, I think I would have had more on it as well. So mostly it came up in the reply. And so this is my only opportunity to respond to it. If the court requires further briefing, I would welcome the opportunity to do so. I want to conclude now and just say that there was no error in the jury instructions here. There was no defense of another jury instruction warranted. So yes, while the instruction was defective, it was not a plain error under the 4-part plain error test. And there was also no mistake as to the intoxication jury instruction for the reckless crimes, because it also was not warranted given the contents of the more specific statute over the general, and therefore the people asked this court to affirm the judgment below. Thank you.
Ms. Woloschuk,
Yes, Your Honor.
in applying 7.58, the court would have had to reach certain factual conclusions. Aren't those conclusions best left to the jury? Shouldn't there have been a better instruction on this?
Your Honor, I agree that jury instructions can always be better than they seem to be. But in this case, they weren't so defective that a new trial is warranted on this issue. And therefore, that's why we ask that the court affirm the judgment below.
Thank you.
Attorney Maher, you have, as I recall, a little over 3 minutes remaining on your rebuttal.
Okay, thank you. Well, we dispute this notion that the evidence was overwhelming. I go back to the transcript of 1023-18, and they're asking the officer, do you recall what he said to Malo when Malo was striking him in the head? Do you recall what he said? That part I do not remember, answer Detective Chavez. Question, just to direct your attention over here, this is now published. I grabbed the pipe, threw it away, quote unquote. Malo took it from the ground and I told him to whack him over the head, over and over. That was the statement from the prosecutor. Is that consistent with your oral statements? Is that consistent with what your oral statements were from him? Answer, it sounds like, yes, that's what he wrote. So I'm trying to remember whether he told me that or not. Once again, our position is, one, it wasn't overwhelming because of the ambiguity, and Mr. Spivey cleared it up on page, I believe it was page 62 and 63. But also, the Jones case, this court held in the Jones case that Mr. Jones used excessive force. He had a knife, the victim didn't have a weapon, and that he actually stabbed the victim in the back. So here we have an instance where Mr. Simiron's position is Mr. Malo is using the excessive force. And it's just not factually on all fours with the Jones case. The Jones case, there wasn't any real dispute about what had happened. He just simply said he had essentially the right to use a knife to kill a guy who didn't have a knife, and then stabbed him in the back. Now, as to Exhibit 58, the court asked about whether the government objected. That's ER 58. It's on page 5 of the reply brief. The judge asked the parties if they were okay with the force and the defense of others instruction. Mr. Brown said, he said basically, yes, they're okay with it. He had no objection. So I don't think it's proper for the government to be arguing now that somehow that was a mistake or that they really objected but didn't say they objected. And the underlying importance of the instructions is this, and it's not a matter of record. It's what we all experience, though, when we do trials, is jurors hang on the words of judges. They do. Everything they say, every instruction that is given, and they often ask for clarification of the instructions because the instructions are confusing. We had that in this case. The trial judge was requested to give a clarification, and the trial judge did. So the importance of correct instructions cannot be overemphasized. And I say that in response to the government's argument that Mr. Simiron's rights were not substantially prejudiced by these errors, specifically the defense of other instruction, because they are very, very important. Now, I would agree statutory interpretation that the specific controls the general, but I would not say that 4.30 is just a general statute. It's the statute that defines culpability. It's not just a general statute.
I'm going to ask you to wind up, Mr. Ma.
Okay.
Can I just ask one quick question? The government objected to any instruction on self-defense in this case, correct?
No, I didn't see an objection. That's correct.
If you look at it, you're saying you didn't see. If you look at the transcript on October 29th on page 88, the judge is bringing up the issue of self-defense and the justification. And she asked if there's an objection to this inclusion, and Mr. Brown says yes. And so he makes an argument that self-defense is limited and it's not justifiable to use self-defense. So there seems to be some objection on at least the self-defense instruction.
Okay.
So does that make it a little different than the White situation where there was an explicit acquiescence and in fact an acknowledgement that the government believed in White, there was the government expressly stated there was evidence to provide the jury instruction?
Well, thereafter, same date, the 29th of October, the courts asked, okay, all right, so for 5X, that's the instructions that I just indicated with force, that's the self-defense, and defense of third person defined. Any objection for the record? Mr. Brown, no, Your Honor. So either he had a change of heart or he realized that it was warranted, which would be the same thing. But he, at the end of the day, when he had his opportunity to object, he did not object. So is that invited error? I mean, I don't know how to reconcile the government's position.
Okay.
Thank you. Thank you, Justice Torres.
Thank you.
Honor, your time has expired. Thank you, counsels, for your arguments. The court will take the case under advisement and will issue a written opinion at a later date. At this time, the court stands adjourned.
Okay.
Thank you, Counsel.